People have heard about reaffirmation agreements, and they'll say, well, I reaffirm something in their bankruptcy, a Chapter 13, or in their Chapter 7. First, a reaffirmation agreement doesn't exist in a Chapter 13 bankruptcy. In a Chapter 13 bankruptcy, you're paying on the vehicle or on the item you would reaffirm what you would keep over a period of years through the bankruptcy process. A reaffirmation agreement is something that happens only in a Chapter 7, and that's where when you file your Chapter 7, you're wiping everything out. And if you want to keep something, you've asked to be able to keep it. And the creditor has to agree for you to be able to keep it, so you need to be current on it. And then they give you the deal, which is usually the same terms you had in your prior contract, as far as interest rate, due date, monthly payment. And you've signed that agreement, and they filed it with the court, and then you're now responsible for that item, typically a car. And what happens also with that reaffirmation agreement is it means you're liable on it, which means the debt's not discharged. So if 6 months, a year, or 2 years down the road you're unable to make the payment, what will happen is that they'll repossess the vehicle and they'll be able to sue you for the deficiency because you signed that reaffirmation agreement. It allows you to keep the vehicle, but it also requires you to have all the liability with the vehicle. That's a reaffirmation agreement.